Welcome back. In this subunit, we're going to focus on the formation defenses of illegality and violation of public policy. All right, so we've already gone through many formation defenses. We've already gone through duress, misrepresentation, incapacity, and undue influence. Later, we'll go through unconscionability. In this unit, we're going to focus on contracts that are illegal or contracts that violate public policy. All right, let's begin by talking about contracts that are unenforceable because of illegality. There are three basic fact patterns for you to familiarize yourself with. The first is the contract that involves illegal subject matter. The second is the contract that involves an illegal purpose. And the third one is a contract that involves an unlicensed service provider. All right, so for example, a contract of illegal subject matter, one example is the murder for hire. The subject matter, the murder of somebody, that is illegal. A contract for an illegal purpose, here's an example, someone leases a house to use as a drug den. And the third, unlicensed service provider, let's say an unlicensed attorney enters into a contract to provide services for a client. In each of these cases, the question for the court is, what should it do if one of these parties sues under the contract, either for breach of contract, right, seeking expectation damages, which we'll learn about later in the course, or whether the other party sues to get her consideration. She's already provided the consideration under this illegal contract, and now she wants to get her consideration back. What should a court do? All right, let's talk about the principles that a court will apply in these cases that involve illegal contracts. There's the Latin terms of in pari delicto and malum prohibitum or malum in se, and then there are other principles. So first, let's talk about in pari delicto. In pari delicto means, is the party who is suing either to get her consideration back or she's suing for breach of contract, was she in pari delicto? Was she in equal fault under this contract? So for example, in the case of the contract for murder, the murder for hire contract, basically both parties are in pari delicto. And so the court's not going to give relief to either party in that situation. We'll talk about that a little bit later. Now, let's talk about the idea of whether the law is malum prohibitum or malum in se. Malum prohibitum just means that the law, what the parties entered into the contract for the subject matter or the purpose is illegal only because there's a law that says it's illegal. It's not malum in se. It's not bad in and of itself. So, for example, you need a license to sell soft drinks on the boardwalk, right? Well, why do you need a license, right? Well, it's not malum in se. There's nothing bad about selling soft drinks on the boardwalk. It's malum prohibitum. There's just a law that says you can't do it. And there are reasons why we have that law, but it's not bad to sell soft drinks. Once again, going back to the murder for hire, murdering someone, that's just malum in se. It's bad because it's evil, right? And so it's less likely that a court would enforce a malum in se contract or let one party recover its consideration under a contract that involves something that's illegal because it's malum in se. And it's more likely, but not absolutely a certainty, but it's more likely that a court would give a party under a contract for something that is illegal because it's malum prohibitum. The court might provide some relief to one of the parties in that situation. Then there are other provisions, there are other principles that you want to consider when you get a fact pattern that involves an illegal contract. Can the offending provision of the contract be severed from the contract, right? And then we'll enforce the rest of the contract. Will one party suffer forfeiture, right? Will one party suffer disproportionate loss if we don't let her recover at least something under the contract? And will one party be unjustly enriched if we don't let the other party enforce the contract or receive her consideration back? All right, let's just quickly explore the three different types of contract illegality fact patterns that we might see, and do a superficial analysis of how a court might decide. So let's talk about the illegal subject matter, right? The murder for hire. When the person has already paid the hit person, can that person recover her consideration, right? Well, are the parties in pari delicto? Well, yes. The person who is suing to get her money back, she's in pari delicto. So it's unlikely that the court would protect her or allow her to recover any money. Is it malum prohibitum or malum in se? It's malum in se, right? Murdering someone is bad because it is evil. It's bad in and of itself. And therefore, it is less likely that the court will allow the person who hired the hitman to recover the consideration she already paid the hitman, right? Is there forfeiture and unjust enrichment? Yeah, there's probably both in this case. The party who has already paid and hasn't received her services in return is probably going to suffer forfeiture, but the court is probably not going to care in this situation. And the hit person who received the money is probably going to be unjustly enriched, but the court, once again, is probably not going to care. The court doesn't want to get involved in splitting up money between two criminals. All right, let's look at the situation where we have a contract that involves something for an illegal purpose. So our fact pattern was that there was a house lease between a landlord and a tenant, and the tenant intended to use the house as a drug den. Let's assume the lease is for 12 months, and the tenant is arrested after 6 months, and the landlord sues the tenant for breach. Will the court enforce this contract? Will the court provide any relief to the landlord? And once again, we go through the same type of analysis. Was the landlord in pari delicto? Did the landlord know about the illegal purpose, right? If the landlord knew, then we might say the landlord's in pari delicto. Did the landlord provide any type of assistance, right? Did the landlord say, you're having a drug den? Well, let me put up a fence. Let me add some security measures. Let me tell the neighbor next door who's going to look out for you if the police come, something like that. In that case, then the landlord is in pari delicto, and the court will probably not provide the landlord with any type of recovery under this contract. Malum prohibitum or malum in se? Selling drugs is probably malum in se. Forfeiture or unjust enrichment? Well, in our case, I don't see it. There's not forfeiture. The landlord is now getting the residents back, and the landlord can rent the house to someone else. So it doesn't look like there's a great amount of forfeiture on the part of the landlord. Unjust enrichment on the part of the drug dealer, I don't see it here anyway. It doesn't look like the landlord paid anything up front to the drug dealer, just promised to give occupancy of the house to the drug dealer for 12 months. All right, so here's the law. The party without the illegal purpose, in our case, the landlord, will generally be able to recover under the contract for breach of contract if she did not know of the illegal purpose, right? If the landlord didn't know that they were using the house, they planned to use the house for a drug den, or she knew, but she did not facilitate the illegal purpose, and the crime did not involve serious moral turpitude. So let's just assume she knew, but she didn't facilitate it. Well, I think selling of drugs involves serious moral turpitude. So if she knew, but didn't facilitate it, she still probably won't be able to recover under the contract, because this is a crime that involves serious moral turpitude, whatever that is. For me, drugs and murder is serious moral turpitude. All right. The third fact pattern we looked at was the situation where we had an unlicensed service provider. So our hypothetical was an unlicensed attorney who enters into a contract to provide services to the client. For whatever reason, the unlicensed attorney doesn't provide the services, and the client sues for breach. So is the client in pari delicto? Probably not. Probably this rule, the requiring a license for an attorney is there to protect the client. So probably the client is not in pari delicto. It might be different if the client knew that the attorney was unlicensed and used the attorney anyway. Malum prohibitum or malum in se. Here, probably malum prohibitum and not malum in se. Providing legal advice to people while you shouldn't do it if you're not a licensed attorney is just advice, and it's not like killing someone or selling drugs, I suppose. Forfeiture or unjust enrichment. Well, is there forfeiture here? Well, nothing in the fact pattern indicates forfeiture. Maybe the client has paid a retainer, like a $20,000 retainer to the attorney, in which case then the client would suffer forfeiture if we did not enforce the contract in some way, or at least make the attorney return the $20,000. Unjust enrichment, well, same thing in this case. If the client has paid a $20,000 retainer and we let the unlicensed attorney keep it, then the unlicensed attorney will be unjustly enriched. Probably in this case, the court will require the attorney to at least pay back the $20,000 and maybe even allow the client to sue for breach of contract. I contracted for you to do this and you didn't do it. Now I have to get someone else to do it. It's going to cost me more to get someone else to do it. So I want the difference between what you were going to charge me and what this real attorney is going to charge me. So what if the attorney without the license sues for the services she's already provided to the client? Well, the rule is that if the licensing regime, if we have a licensing regime because we want to raise revenue, then we might let the unlicensed service provider or the unlicensed seller of goods recover for what she's provided to the other party, right? So if we go back to the situation where we're talking about the person who sells soft drinks on the boardwalk, right? And for some reason, this person enters into a promise to sell the soft drinks on the boardwalk. And now we're saying, no, you can't do that. The contract is unenforceable because you don't have a license to do that. And the question is, well, I've already provided the soft drinks to the person. I just want to get paid. Probably, right? Why? Because that licensing regime is there to raise revenue and not necessarily to protect the public. Why do we give licenses to attorneys? Well, we want to make sure attorneys are competent. So the licensing regime for attorneys is most likely there to protect the public. And when the unlicensed attorney sues to recover for the services she has provided, the court will probably not allow that attorney to recover those fees. Now let's talk about contracts that are unenforceable because they violate public policy. Right? There are several common situations that you'll run into. By no means is this an exhaustive list, but these are the most common fact patterns that you will see. So we have a contract that results in an unreasonable restraint in trade. We have a contract that limits one party's liability for its reckless or intentional misconduct. We have contracts that result in an unreasonable restraint on marriage, contracts for the custody of children, and then there's the other broad category, other public policy. So let's first focus on contracts that limit liability for reckless or intentional conduct, contracts that result in an unreasonable restraint of marriage, and contracts for the custody of children. These are more simple fact patterns. All right, first, let's talk about a contract that limits liability for reckless or intentional conduct. Here's a typical example. You join a gym, you become a member of this gym, and they ask you to sign a membership agreement, and it might have this clause in it. The gym shall not be liable for any reckless or intentional conduct that results in injury to you, the member. Is this enforceable? And the answer is probably no. It's a violation of public policy. Now, this clause says the gym shall not be liable for negligent, reckless, or intentional conduct. So the limitation of liability for reckless or intentional conduct is probably not enforceable because it's against public policy, right? We don't want people to be engaging in reckless or intentional harm. So we don't want to encourage them to do that, so we're not going to let them enter into a contract that limits their liability for engaging in reckless or intentional misconduct. The second part of it, or the other part of it, is whether the gym will be liable for its negligent conduct. And the law will allow you to disclaim your negligence. It will allow you to disclaim liability for negligence. So that part of the clause will probably be enforceable. Let's talk about contracts that unreasonably restrain a person's ability or right to get married, right? For some reason, maybe I shouldn't have said it that way, but our society likes to encourage people to get married, right? We consider marriage a bedrock of our society, and we can debate that, but it's been kind of ingrained in the law. So we'll assume it is for the purposes of understanding why a contract that restrains one's ability to get married could violate public policy. So there are two common fact patterns: a contract that totally prohibits someone from getting married, and a contract that prohibits a person from marrying for a certain length of time. So if the contract totally prohibits someone from getting married, even though that person agreed to it, right? They entered into a contract, they say, you pay me $1 million and I won't get married. The contract is unenforceable because it violates public policy. But if, for example, the father says to the daughter, listen, if you don't get married and you take care of your mother for the next 5 years, after that you can get married, I will pay you a certain amount of money. That contract is probably enforceable, right? A court will entertain the possibility of declaring that a reasonable restraint on marriage because it's for a relatively short time, and there is apparently a good reason for it, at least there is in this contract. The next contract that violates public policy are contracts for the custody of children. Now, we know this happens all the time. We have divorcing parents and they agree that the father will have custody, the mother will have custody, that parent will have custody, this parent will have custody, or they'll have joint custody. Technically, this agreement is unenforceable because it violates public policy. Now, the court might respect it, but not because the court is enforcing the agreement. The court is respecting it because the court has done an independent evaluation of what the best interest of the child is. So you're going to see this throughout law school. When a child is involved, the standard is generally going to be, is this in the best interest of the child? So a court might respect the agreement, but it's because the court has done an independent evaluation of the best interest of the child. If the parent's custody agreement is not in the best interest of the child, the court will not enforce it. Let's move on to our last category of contracts that violate public policy: contracts in restraint of trade. What are you going to see? Well, mostly you're going to see non-competition agreements. And you're going to see non-competition agreements in two different broad categories. The first are non-competition agreements between competing businesses, where they agree not to compete in the same territory. Listen, you take that territory, I'll sell in this territory. This is competing businesses. Or they agree to fix prices. They say, listen, we sell the same goods or services, let's fix the prices, so let's stop competing with each other. These agreements are against public policy and are not enforceable. There are also statutory laws against this. There are state laws and federal laws that prevent this, but common law contract law will say that these contracts are not enforceable. The next situation is a non-competition agreement entered into between an employee and an employer, or between the owner of a business who is selling a business. So for example, the employer employs the employee, and we saw this when we talked about consideration and employment at will. The employee signs a non-competition agreement saying, when I leave work here, when I leave your employment, I will not compete with you. We talked about whether there's consideration. Now we're going to talk about whether this type of non-competition agreement violates public policy. The same situation where we have an owner of a business who is now selling the business. Imagine you're buying a business and you buy it from the owner. You want that owner now not to compete with you. Otherwise, why would you buy the business? Let's talk about whether a non-compete in the employment context or the sale of business context is enforceable, or whether it violates public policy. Here's the law. A non-compete agreement is enforceable if, first, it is ancillary to a legitimate transaction. So the non-compete in the employment context is ancillary to a legitimate transaction, the employment relationship between the parties. The non-compete in the context of the sale of the business is ancillary to a legitimate transaction, the sale of a business. All right. The non-compete must also be reasonable with respect to scope, geography, and duration. Here's a little tip when you're analyzing whether the non-compete is reasonable with respect to scope, geography, and duration. Consider whether it is narrowly tailored to protect the party's interest. In the case of the employment context, is it narrowly tailored to protect the employer's interest? In the case of the sale of the business context, is it narrowly tailored to protect the business buyer's interest? So, for example, imagine I employ you as a manager of a tire store and I ask you to sign a non-compete. The non-compete says that when you leave my employment, you can't work for any competitor as a manager of a tire store. Okay? This is probably reasonable with respect to scope. Why? Well, your duties with me was the manager of a tire store. I have asked you not to work for one of my competitors when you leave my employment in that same position. If the non-compete had said, I promise, the employee promises not to work for any competitor in any context, right? I can't work for any tire store in any position. That is probably unreasonable with respect to scope. Now, the non-compete must also be reasonable with respect to geography. Just quickly, if I ask you to sign a non-compete that says that you will not work for a competitor, another tire store, as a manager of another tire store, anywhere in the United States, that is probably unenforceable. It's probably too broad. Is it narrowly tailored to protect me, the employer? Well, from where do I draw my customers? I draw from my customers in this local area only, not in all of the United States. So consider that when you're doing the analysis. The employer, where does the employer draw customers from? Where does the employer do business? The third issue is whether the non-compete is reasonable with respect to duration. Now, here's a tip. When lawyers nowadays are drafting non-competes, 2 years is kind of the outer limit. Anything over 2 years, they're going to be worried that the court is going to say it's not enforceable. So a non-compete that doesn't have a duration, or it says it's forever in perpetuity, probably going to be unreasonable with respect to duration. A non-compete that is for 5 years, 6 years, 7 years, there is a high risk that a court would say that that non-compete is unreasonable with respect to duration. Now, here's a question. What will a court do if it says, for example, that the scope is unreasonable, or that the duration is unreasonable, or that the geography is unreasonable? Well, the court could take one of three approaches. The first approach is just to say the contract is unenforceable. The non-compete is unenforceable. The second approach is that the court could rewrite the non-compete so that it is reasonable. So, for example, if you put in the non-compete that the employee promises not to compete for 10 years, and the court says, no, that's unreasonable. The court will say, but we'll enforce it for 2 years. So the court rewrites the provision and makes the non-compete enforceable. The third approach is called the blue pencil approach. And the blue pencil approach is the court will not really rewrite it, but if the court can cross things out and thereby make it reasonable, then the court will do so. So, for example, imagine our geography of our non-compete is Ohio, Kentucky, West Virginia, and Indiana. And the court says no, and the contract lists all those states: Ohio, Kentucky, West Virginia, and Indiana. Lists those 4 states. And the court adopts the blue pencil approach. The court first says, well, no, that geography is too broad. We'll narrow it. But the court won't rewrite it. What the court will do is say, you know, really, Ohio is reasonable. So what we can do is we'll just cross off Kentucky, we'll cross off West Virginia, and we'll cross off Indiana. And that leaves Ohio in the contract. So blue pencil, or you can think of it as a red pencil approach. I might use a red pencil. Here's how the blue pencil would approach in, for example, duration. So for example, maybe the parties in the non-compete say that the employee will not compete with the employer for 5 years after leaving employment. So in the unenforceable jurisdiction, the court would just say that's unenforceable. It's the duration is unreasonable. In the rewrite provision, the court would rewrite and say, well, 5 years is unenforceable, but 2 years is reasonable, and so we'll enforce it for 2 years. In the blue pencil approach, the court would look at 5, and there's no way to cross off 5 so that it leaves you with 2. Do you understand? If you cross out 5, then it's nothing. So in the blue pencil approach, the court would be forced to say, well, we can't blue pencil this to make it enforceable, so it is unenforceable.